Good morning to everyone. This is Sudhir Babu. So I was studied the Constitution of India. So in that Constitution, I found a few illegitimate things. So that I need to claim that one, or I need to rectify those illegitimate things. Due to that, I went to consult High Court of Hyderabad. So in that High Court of Hyderabad, my case was registered. The registration number 1381 HCL SC /2019, and the same thing I was got a reference certificate from High Court of Hyderabad. Vindyalaya Madam Garu referred my case to Supreme Court. But unfortunately, I failed to reach the High Court or a Supreme Court because due to some problems, because in High Court of Hyderabad they refused because of my native place is Andhra Pradesh. That's why after the Vindyalaya Madam Garu, who came as a returner, that particular returner got not supported for my case. So that only I sent to Supreme Court, whatever it may be, the reference given from High Court of Hyderabad legal aid, and as well as a certain what I had. What I have a documentary, and the entire documentary I was sent to Supreme Court. But Supreme Court legal aid also written back those complete documentary, because the reason is the entire documentary, and as well as whatever it may be, the documentary I was sent to Supreme Court, that documentary is not a proper protocol, because the court having a certain protocol. So my documentary is not in that particular protocol. That's why they rejected. I mean, the legal aid not accepted to refer to the Supreme Court. So that one registered in Supreme Court legal aid 9926 slash SC SCL SC /2019. So it's been completely here. I failed to reach the court through the lawyer, because I don't have a ability to go through the lawyer, because lawyers will take a much more amount. Maybe I don't know how many years this case will extend in the court, so that I don't have ability to uh, go through the lawyer. And as well as I went to consulted legal aid. So unfortunately legal aid also didn't help for me. That's why I decided to reveal everything um, through the media. That's why this particular video also I'm doing and keeping in social media for citizen support. So what actually here my accuse in the sense, basically three illegitimate things. The first one is Article 105 Class 2 is not a legitimate provision. What actually the Article 105 Class 2 in the sense, whatever it may be, the voting in the Parliament, the court will not take any action on a political leader, whether the voting is a right or wrong, I mean legitimate or illegitimate. But the court will not take any action on the political leaders. This is the actually provision 105 class 2 provision. So according to my opinion, in my study, this particular 105 class 2 is not a legitimate provision. Okay, this is the first one. And the second one is speaker privileges are not proper privileges. It's mean not a legitimate privileges, especially before going to form a government. Any leader done a defection, I mean, through the defection only the government will form in the parliament. On that particular case, speaker is not a right person to take a decision make on that. So this is not a legitimate. We will discuss later why the speaker privileges are not a legitimate privileges. So this is the second one, and third one is in 1993, no confidence motion case. Supreme Court given one arbitration in 1998. Okay, so in that case, given arbitration is whatever it may be that happen in the parliament, the court doesn't have a right to take any criminal action or a civil action on a political leader. The only one penalty for a political leaders to expulse from the parliament. It's mean expulsion from the parliament means తెలుగులో చెప్పుకోవాలంటే బహిష్కరించడం parliament. That is the only penalty for political leader. This is the arbitration given by the Supreme Court. These three things are not a proper. That is actually my accuses. Okay, so before going to explain these three, first we need to think about, so who enacted 105 class 2. This is not a meaning to humiliate that particular government, because already that government passed away. And the second thing is the arbitration is completely different for different way of thinking nature of judges. So we cannot completely humiliate or point out the judgments. So the meaning of this one is requesting to Supreme Court, you have to re-review on this particular issue once again, and the court need to think about my point of view also for our nation. Okay, so this is not a my personal issue, and this is for the nation. So the court need to think about what is my grievance actually on this. As a citizen, I need to rectify my doubts here, and according to my point of view, this is not a legitimate. That is my accuse, but this is not a meaning to derogation the Supreme Court values. And the third thing is who is the major senior political leader including in this particular 1998 case. So this is not a meaning to damage that particular political leader reputation, and this is not a meaning to reopen that particular leader case, because that one is not a mandatory for me, and there is no any useful for me also, and for nation also. So the meaning of this one is to explain these improper things based on this particular 1998 case. So this case is very useful to explain everything. It's mean this is a one best example for to give the explanation for those three legitimate things. And the fourth one is the exact meaning of democracy is completely depending upon the balancing between the constitution and as well as leadership qualities. If all the leaders are perfect, but the constitution not support for good political leaders, in the sense democracy will be damaged. But the constitution provisions are completely legitimate and perfect, but the political leaders not norm for the constitution also, democratic values will be damaged. Okay, so it's mean we need to balance the constitution and as well as leadership qualities. So constitution provisions also very important to conserve the democratic values in the nation. So this is very, very important point. And the final thing, fifth point is, what is the major thing here I am talking about? The fifth point is, so if any case like 1993 case once again repeat in the nation, um, the duration of time period to take a decision make on that particular case, the nation will get a damage. It's mean damage in the sense, suppose for example, in 1993 no confidence motion, the result will the result came in 1998, the year 1998. It's mean the court took 5 years duration period to take a decision made on that. Okay, the same thing, if any case the same situation will arrive in the nation, the court will take a lot of time to give the arbitration on that particular issue. So that duration of time period is waste for the nation. And when the court will take a decision make on that, before already, before the nation degrading the nation prosperity. Okay, so that's why here I am getting to good arbitration once again on these particular three issues. So this thing is very, very useful for our nation. It's mean for future scope we can completely change and we can completely abstract the same situation will arrive in the sense we can abstract early and as well as. Okay, that is the major reason here I'm accusing on these particular issues. Okay, the court and parliament and every Indian citizen need to understand. Okay, so then we will go for explanation why those three things are legitimate. The first thing is, here majorly I am talking about um, in 1965 case was in case on 122 article, the Supreme Court given on arbitration. What is that arbitration? What actually the 122 article first? So 122 article is a immunity for political leaders. That immunity given by the Constitution. Okay. So on that particular 122 article, Supreme Court given in 1965 case was in case. What is that arbitration in the sense? If any case, contempt of constitution, contempt of constitution in the sense unconstitutional things and as well as illegal activities. On these two particular issues, there is no any immunity for political leaders. It's mean in contempt of constitution case and illegal activities case, the 122 article is not applicable. That is the arbitration given by the Supreme Court in 1965. What is the exact overall meaning of this arbitration in the sense? Yes, exactly. The court also agree with 122 article. 122 article giving the immunity for political leaders, but not giving the immunity for political leaders from the Constitution. That is the major overall meaning of the arbitration. It's mean Constitution giving the immunity for political leaders, but not giving the immunity for political leaders from the Constitution. If any case, Constitution giving the immunity for political leaders from the Constitution in the sense, who getting the immunity from the Constitution, that particular political leader only the sovereign, but not a Constitution. Basically, a Constitution is a sovereign in the nation. It's mean the Constitution is a supreme lex in the nation. There is no any other person more than on Constitution. It's mean everyone need to bend their head in front of the Constitution. That's it. No one more than the constitution in the nation. That is the meaning of the arbitration. What is majorly my accuse here in this point, in the sense, what contempt of constitution is not applicable for 122 article, and why the contempt of constitution applicable for 105 clause 2. So contempt of constitution is completely offense in the sense, I mean, the constitution not giving for any political leaders from the constitution, in the sense, no one will not get immunity from any article. It's mean either that one is a 122 article, 105 class 2 article, or other any article. It will not possibility to get the immunity. Then why you completely abandon 1993 case? So what is the major difference between 122 article and 105 class 2 article? Why contempt of constitution is not applicable for 122 article, and why contempt of constitution is applicable for 105 class 2? This is my first accuse. And the second thing is history of 105 class 2. This 105 class 2 enacted in Srimati Indira Gandhi government. Okay, and after this 105 class 2 enacted, a few years, Rajiv Gandhi Gari government enacted anti-defection law in our constitution. When anti-defection law enacted by the parliament at the time, this 105 class 2 existence completely collapsed. So whenever the parliament enacted one thing in the constitution, so that one also part in the constitution. So that one also part in the constitution, in the sense, the Supreme Court having a rights to conserve that particular concept, what actually the parliament enacted in the constitution. So Rajiv Gandhi Garu enacted anti-defection law, in the sense, defection is a contempt of constitution. So the sentinel body, who is a sentinel body? The Supreme Court is a sentinel body, need to give you the constitution always. So the sentinel body need to conserve the constitution values always, so that the Supreme Court having a rights, it's mean deserve to take any action on a defection also. But the parliament completely obstructed due to based on the 105 class 2. Okay, so it's mean the anti-defection law and 105 class 2, these two are completely enacted by the parliament in a different occasions and a different duration of periods. So these two are not a balanced condition right now. So anti-defection law is there in our constitution, in the sense defection is a completely contempt of constitution. So before enacted anti-defection law, so defection is not directly contempt of constitution, but defection is damage the democratic values. It's completely we can agree with that. Okay, so defection is completely damage the democratic values, but that one is not directly contempt of constitution. But when we can enacted anti-defection law in our constitution, so defection is directly contempt of constitution. That's why 105 class 2 is not a proper provision. So parliament doesn't have a right to obstruct the sentinel body, if any case, especially in a contempt of constitution case, because judiciary is a basic structured doctrine in our constitution. It's mean judiciary is a base point in our constitution, so that the court, the parliament doesn't have a right to do the against to basic structure doctrine. So any provision against to basic structure doctrine. Okay, if any case the parliament enact um, more than a basic structure doctrine, in the sense the meaning of that one is limited amendment power completely converted into unlimited amendment power. So parliament doesn't have a right to um, get the unlimited amendment power because in our constitution there is a limited amendment power to the parliament. Okay, so here in especially in one of our class 2 case, the parliament got that type of unlimited amendment power. That is also one of my accuses. And next third one is very important. So basically here the court not talk about there is no any action on political leaders when the political leaders done a contempt of constitution in the parliament premises. But the major thing actually the court talk about here, the action will take in a parliament premises by the speaker, but not by the court. This is actually the court talking. Okay, that is the reason only Supreme Court abandoned this particular case. It's me, whatever it may be the happen in the parliament. So in the parliament premises, completely every decision only made by the um, speaker only, but not Supreme Court. Okay, this is majorly the Supreme Court will give the answer for this one simply. But what is the major thing here I am talking about? The speaker privilege is also one of my accuses. Basically, why in the sense you remember here I am talking about, we can explain why speaker privileges are not a proper privileges and not a legitimate privileges. In the parliament there is no any government, there is no any government in the sense there is no speaker, there is no speaker in the sense if any case political leader done a defection, who will take a decision make on this? But here there is a one logical point. What is that logical point? In the sense there is no government in the sense, there is no government in the sense we cannot define the defection, because how we can define the defection? After form the government only we can define the defection, because we will go to court and ask, or we can accuse few leaders may be chance to doing a defection and form the government. So it's mean based on the defection only um, one political party will form the government in the parliament. It's mean before going to form the government will approach the Supreme Court on this particular defection case. The Supreme Court will not take a case, will not take the case, because murder is a crime and attempt to murder also crime, but attempt to defection is not a crime, and attempt to defection case court will not take any case on that particular issue, because when we will confirm the defection in the sense after form the government in the parliament, we can confirm the defection. At the time only the court will take a that particular case. Okay, and the government form in the sense defection will confirm, but and as well as the government form in the parliament in the sense there is a speaker, then the court completely sent to I mean whatever it may be the judiciary on this, the entire matter passed through I mean giving to uh, speaker. I mean always the decision maker only the speaker actually here court talking. Okay, but my major question is here, the government didn't form morally, because the government formed in the parliament fraud. That fraud government elected one speaker. How that speaker is a moral? How that speaker having a right to take a decision make on that? That is my question here. So it's simply we can think about that. So one person done a crime and came to court, but the court giving the opportunity for to take a decision make on that to that particular criminal. The criminal will take a decision make on him by himself. It's mean that particular criminal will take a penalty on him by himself. Is it possible? It's mean the particular criminal will not give any imprisonment for him by himself. It's an impossible thing. Is it right? The same thing here also. The government form completely fraud. That fraud government elected one particular speaker. How the speaker will take a decision make on that? If speaker will take a decision make on that, it's completely, and who done a fraud in this particular government. So the speaker will completely expulsion from the parliament who done a mistake in this particular government, how to form the government, that particular who done a particular mistake in that particular case, and completely those political leaders expulsion from the parliament. In the sense, once again the government will collapse. The government will collapse in the sense speaker post also collapse. Speaker will lose his post. Okay, so he can lose his post in the sense how he can take a decision make on that. No one will not take any decision maker according to their losses. I mean, if any person will get a loss from anything in the sense, the person will not take a decision make on that. If it is completely impossible condition. Okay, so what is the major thing here I am talking about? But you can give the answer, and you can talk about here. Speaker is not belongs to any particular political leader. It's completely the speaker is completely out of all the political parties in the sense. Then here my question is, why the government will collapse in the sense again speaker will change. Suppose, for example, any government will change in the nation or in the state, the governor and president will not change. But each and every changing of government in the nation or in the state, so whatever it may be the case, completely the speaker also change. The best example, Karnataka. So in Karnataka, first form the government Devagowda Gari son Kumaraswamy Garu. Okay, so that Kumaraswamy Garu elected one particular speaker in his government. So after Kumaraswamy Garu government collapsed in Karnataka, and again government formed by the BJP party. So that BJP party elected another speaker. Is it right or not? So it's mean government has been continuously changing. If any case, definitely the speaker will change. Okay, the speaker post is not constant according to our constitution. Or constitution or whatever it may be, the political issues, case whatever it may be. So here we can think about that. Okay, it's mean the speaker is not a right person to take a decision make on before going to form the government if any leader done a defection in the parliament. So on that particular issues, speaker is not a right person to take a decision make on that. It's mean it is not a legitimate. It's completely out of. It's mean there is no government in the parliament. There is no speaker to take a decision make on that. If government will form fraudly in the sense that fraud government elected one particular speaker, that speaker also under the fraud. So under the fraud in the sense that fraud speaker I mean the particular speaker having a right to take a decision make on that. It's completely unlegitimate. It's mean illegitimate thing. So that's why speaker privileges are not a proper privileges. This is the major thing here I am going to talk about here. And the next point is here, I am going to think about. So if any case, who voted to particular political leaders or a political party, and if any case the political leader done a defection and jump from one party to another party, the citizen having a right to question that one. So if a citizen having a right to question that one in the sense, where will the citizen will go to question that? I mean, where will go to question that particular issue on particular issue? So to the court or to the speaker. I mean, we can completely complain to speaker or to the Supreme Court. That is major accuse. Suppose for example, you can talk about you can completely complain to speaker in the sense how the citizen will go to complain to the speaker. I mean the citizen doesn't have a rights to go to the parliament. It's completely out of. There is no any proper protocol in our nation to consult the speaker to give the complaint on that particular political leader. It's completely out of. So the citizen having only the possibility to approach the court only. But court talk about here in constitution there is a 105 class 2 article. So that's why court doesn't have a right to take a decision make on that or take any action on that particular thing, because if any case the court will take a decision make on action on that particular thing, the court will do the contempt of constitution. It's mean that one is not a proper. And that's why court will not take any action or a court will not take any decision make on that. It's completely if any case the court will take that particular case complete judiciary and the entire thing is submitted to speaker. Once again speaker hold that particular thing and speaker will not take decision make on that. If any case speaker will take a decision make on that, that one will be maybe a chance to last for that speaker political party. Basically speaker is not belongs to any political party according to the constitution, but indirectly speaker is belongs to one particular ruling party. So it's all obviously in our nation. But maybe this is right or wrong to talk about directly outside, but I don't know that. Okay. And one more thing is here I am talking about the speaker is not a right person. That one is one accused. And the next thing is here majorly here I'm talking about there is no any proper protocol to approach the speaker, and only the citizen having a possibility to approach the Supreme Court only. So that 105 class 2 is not a proper provision in the constitution, and that is also one more thing. And next point is the majorly we can the speaker also under the judiciary, because on speaker Supreme Court given one arbitration. I don't know exactly year when actually Supreme Court given that particular arbitration, but what is that arbitration in the sense? Speaker is under the tribunal, under the tribunal, I mean, speaker is also under the tribunal. Uh, that's why whatever it may be the decision made by the speaker, so that particular decision also need to now for the judiciary. It's mean under the judiciary. Okay, so it's mean speaker also under the judiciary. And one more thing is speaker is not a proper person to take a decision make on that. Okay, not a legitimate. So due to these particular things, I can talk about 105 class 2 is not a proper provision. What actually here my accuse in the sense, maybe what actually 105 class 2 article here, freedom of vote in the parliament, and court will not take any action on that. So that is a 105 class 2 article. Okay, so freedom of vote, we can provide for a political leader is not a illegitimate, but the tag is illegitimate. So suppose for example we can think about 105 class 1. So what is 105 class 1 in the sense of freedom of speech for a political leader in the parliament, but and as well as the tag for that particular 105 class 1 is need to now for the constitution. It's mean all the political leaders having a freedom of speech in parliament based on 105 class 1, but the political leaders need to now for the constitution. That one is a tag for 105 class 1, but in 105 class 2 tag is completely different. What is the tag in the sense? There is a freedom of vote, but not to take a action on a political leaders on that particular issue. That is a tag. So the tag is not legitimate. Okay, freedom of vote also may be acceptable, but the tag is not a acceptable because judiciary is a part in basic structure doctrine. Okay, that's why that particular tag is not a proper. That is my accuse majorly here. And one more thing is, one more point here majorly I am talking about. Um, there is a constitution in the parliament. Definitely in that in that constitution there is a judiciary. So we cannot use without judiciary constitution parliament. No. So it's mean there is a constitution in the parliament in the sense definitely there is a judiciary in that particular constitution. So we cannot refuse that particular constitution. So that is also one of the question here we need to think about. So why we need to think about in the sense directly there is no involvement in parliament to the court, but if any case uncircumstances in the nation or any abnormal condition, the court need to involve in parliament also sometimes because the all the parliament debate there is a record. Okay, the court having a rights to observe to audit that particular records. Okay, that is also one of the important point. Okay, suppose for example the Supreme Court arbitration uphold by the Supreme Court and as well as Parliament in a sense. Here simply I am asking one question. What is that one in the sense? In the Parliament, if any case one opponent political leader assassinate one ruling party leader or otherwise one ruling party leader assassinate one opponent political party leader in essence, court will take a action on that, court will involve in that particular case or not. That is my question. If what is the meaning of this one in essence? In 1998 case Supreme Court given arbitration is whatever it may be the happen in the parliament, court doesn't have a right to take any criminal or civil action on a political leaders. The only one penalty for political leaders to expulsion from the parliament only. That one only the imprisonment or a penalty for political leaders. That one I actually talk about Supreme Court here. So, according to that particular arbitration, here I am asking, so you are giving the exception only for bribe but not assassination. It's mean you are given exception for one political leader but not giving a exception for other political leader. I mean any another political leader. And one more thing is you given exception in one crime. What is that crime? Bribe taking or given whatever it may be in that particular, including in the parliament. Okay, so you given exception for bribe, but you are not giving exception for assassination. So here it's mean this is not a proper rule of law, no. So according to your arbitration, according to the rule of law, so whatever it may be the crime, whether that one is a assassination or a bribe taking, bribe also crime, assassination also crime. So you giving the exception for a bribe in the sense assassination also there is an exception for political leaders in the parliament. So that is one more question here I am asking. The court need to ask the parliament and then you have to once again you have to give the arbitration on this, because if any case there is assassination, not only assassination, if any another crime also, in that particular another crimes, the court will norm for that, and parliament also need to norm for that. So first that particular arbitration need to norm for the court and as well as parliament in essence. After that I will norm for that arbitration actually. So that is my major thing here I am talking about. Okay, so it's mean if any opponent political leader assassinate one ruling party leader in the sense, so the speaker only expulsion that particular opponent party political leader from the parliament, but not take any criminal or civil action on that particular political leader. For this, that particular ruling party will norm for this, then I will norm for this. It's mean here simply I'm talking about here. So whatever it may be the happen in the parliament, so all the political parties will norm for Supreme Court arbitration, then I will norm for that. Okay, this is major accuse. So it's mean according to the Supreme Court arbitration. So this is also one more major point. It's mean what actually here I am talking about. So the arbitration is not only damage for the citizens and as well as for constitution and judicial values, and also to damage for the political leaders also. Okay, that's why all the political parties and Supreme Court once again need to think about for this particular arbitration and 105 class 2 article and as well as speaker privileges, because these three things are completely much more damage for the society. So this is major my points. So and if any another points on this issue in the sense, and major point, one more major point is constitution is a sovereign in the nation in the sense, definitely we should have to conserve the constitution, and majorly for a Supreme Court it's a mandatory to conserve. So that's why parliament doesn't have a right to obstruct the judiciary, whether in parliament or out of parliament, whether the person is a political leader or a common man. So the court having completely rights to take a decision make on that. Okay, so I request to parliament and as well as supreme court, once again you have to think about on these three, and once again you have to re-review on this. And you have to give a proper legitimate arbitration. I mean, once again you have to take a decision make on this. So I am expecting, I have full completely on supreme court. Here I am requesting the supreme court, the supreme court judges need to think about once again about this one. Because this is a much more damage for our society. So I think according to my opinion. Okay, thank you.